McDonald v. Chicago, 561 U.S. 742, 2010, is a landmark decision of the Supreme Court of the United States that found that the right of an individual to keep and bear arms as protected under the Second Amendment is incorporated by the Due Process Clause of the 14th Amendment against the states. The decision cleared up the uncertainty left in the wake of District of Columbia v. Heller as to the scope of gun rights in regard to the states. Initially, the Court of Appeals for the Seventh Circuit had upheld a Chicago ordinance banning the possession of handguns as well as other gun regulations affecting rifles and shotguns, citing United States v. Cruikshank, Presser v. Illinois, and Miller v. Texas. The petition for certiorari was filed by Alan Gura, the attorney who had successfully argued Heller, and Chicago area attorney David G. Segale. The Second Amendment Foundation and the Illinois State Rifle Association sponsored the litigation on behalf of several Chicago residents, including retiree Otis McDonald. The oral arguments took place on March 2, 2010. On June 28, 2010, the Supreme Court, in a 5-4 decision, reversed the Seventh Circuit's decision, holding that the Second Amendment was incorporated under the 14th Amendment, thus protecting those rights from infringement by local governments. It then remanded the case back to Seventh Circuit to resolve conflicts between certain Chicago gun restrictions and the Second Amendment. Case. In McDonald v. City of Chicago, 2010, Chicago resident Otis McDonald, a 76-year-old, in 2010, retired maintenance engineer, had lived in the Morgan Park neighborhood since buying a house there in 1971. McDonald decried the decline of his neighborhood, describing it as being taken over by gangs and drug dealers. His lawn was regularly littered with refuse and his home and garage had been broken into a combined 5 times, with the most recent robbery committed by a man McDonald recognized from his own neighborhood. An experienced hunter, McDonald legally owned shotguns, but believed them too unwieldy in the event of a robbery, and wanted to purchase a handgun for personal home defense. Due to Chicago's requirement that all firearms in the city be registered, yet refusing all handgun registrations after 1982 when a citywide handgun ban was passed, he was unable to legally own a handgun. As a result, in 2008, he joined 3 other Chicago residents in filing a lawsuit which became McDonald v. Chicago. McDonald v. Chicago as compared to NRA v. Chicago. Despite being consolidated at the U.S. Court of Appeals for the Seventh Circuit, the cases are different in scope in terms of the specific regulations challenged and the legal argument for applying the Second Amendment against state and local governments. The Second Amendment Foundation brought the McDonald case to the Supreme Court with its lead attorney Alan Gura. The cases were appealed separately to the U.S. Supreme Court. McDonald petition for certiorari. Chicago brief in opposition to cert petition. Regulations challenged. McDonald challenged 4 broad aspects of Chicago's gun registration law, which, according to the plaintiffs, prohibit the registration of handguns, thus affecting a broad handgun ban. Require that guns be registered prior to their acquisition by Chicago residents. Mandate that guns be re-registered annually, with another payment of the fee. Render any gun permanently non-registrable if its registration lapses. Legal basis for incorporation. All of the post-Heller cases, including McDonald, NRA v. Chicago, Nordic, and Maloney, argued that the Second Amendment, in addition to applying to federal jurisdictions, should also be applied against state and local governments, using a judicial process called selective incorporation. Selective incorporation involves convincing the court that a right is fundamental by being implicit in the concept of ordered liberty or deeply rooted in our nation's history and traditions as defined most recently in the Supreme Court case Duncan v. Louisiana, 391 U.S. 145, 1968. In addition to claiming the Second Amendment should be incorporated through the selective incorporation process, McDonald is unique among post-Heller gun cases in that it asked the court to overturn the slaughterhouse cases, 83 U.S. 36, 1873. Slaughterhouse determined that the 14th Amendment's Privileges or Immunities Clause did not apply the Bill of Rights to the actions of states, and by extension, local governments. If it had been overturned, the selective incorporation process may have become unnecessary, since the entire Bill of Rights, including the Second Amendment, would arguably be applied to the states. In attempting to overturn Slaughterhouse, this case garnered the attention and support of both conservative and liberal legal scholars interested in its potential application in areas outside of firearms law. Their interest was that if Slaughterhouse had been overturned, it would have been possible that constitutional guarantees such as the right to a jury in civil cases, right to a grand jury in felony cases, and other parts of the Bill of Rights, as well as future court rulings and existing federal precedent, not universally guaranteed in actions by the states, would have been applied against the states automatically. In his concurring opinion, Justice Thomas criticized the Slaughterhouse and Cruikshank decisions, proposing that the right to keep and bear arms is a privilege of American citizenship that applies to the states through the 14th Amendment's Privileges or Immunities Clause. Amici Curiae. 33 Amici Curiae, Friends of the Court. Briefs for this case were filed with the Clerk of the Supreme Court. One of these briefs was filed by U.S. Senators K. Bailey Hutchison, R.T.X., and John Tester, D.M.T., and U.S. Representatives Mark Souder, R.In., and Mike Ross, D.A.R., asking the Supreme Court to find in favor of the petitioners and rule that the Second Amendment does apply to the states. The brief was signed by 58 senators and 251 representatives, more members of Congress than any amicus curiae brief in history. Moreover, 32 states under the aegis of Texas, and California independently, also filed amici curiae. Decision. Central Second Amendment Findings. In People v. Aguilar, 2013, the Illinois Supreme Court summed up the central Second Amendment findings in McDonald. 2 years later, in McDonald v. City of Chicago, 561 U.S. ______________ 130 SCT 3020, 3050, 2010, the Supreme Court held that the Second Amendment right recognized in Heller is fully applicable to the states through the Due Process Clause of the 14th Amendment. In so holding, the court reiterated that the Second Amendment protects the right to keep and bear arms for the purpose of self-defense, ID at _______, 130 SCT at 3026, that individual self-defense is the central component of the Second Amendment right, emphasis in original, ID at ______, 130 SCT at 3036, quoting Heller, 554 U.S. at 599, and that self-defense is a basic right, recognized by many legal systems from ancient times to the present day, ID at ______, 130 SCT at 3036. Majority. Writing for the majority, Justice Alito held that the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. Writing a concurring opinion, Justice Thomas reached the same conclusion regarding the incorporation issue on different grounds, Privileges or Immunities Clause of the 14th Amendment. The majority decision also reaffirmed that certain firearms restrictions mentioned in District of Columbia v. Heller are assumed permissible and not directly dealt with in this case. Such restrictions include those to prohibit the possession of firearms by felons or mentally ill and laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Dissents. Justice Stevens wrote a lengthy dissenting opinion. Among his disagreements with the majority was the statement that incorporation was not at issue in this case. Citing Cruikshank, Stevens wrote, "The so-called incorporation question was squarely and, in my view, correctly resolved in the late 19th century." In addition, he argues against incorporation, taking issue with the methodology of the majority opinions. Justice Breyer wrote, "In sum, the framers did not write the Second Amendment in order to protect a private right of armed self-defense. there has been, and is, no consensus that the right is, or was, fundamental. Reception. The initial reactions of the court's ruling were favorable from both the National Rifle Association and the Brady Campaign to Prevent Gun Violence. Both issued statements to the public that they feel they were vindicated by the court's holding. However, the court did not include a clarification of the standard for review as requested by the Brady Group in their amicus brief. In a discussion on the day of the ruling, Wayne LaPierre of the NRA and Paul Helmke of the Brady Center both agreed that the court's ruling protected specifically against bans on handguns for lawful purposes such as self-protection in the home. But as to the general question of gun laws not covered in McDonald, a large number of lawsuits are needed in order to determine whether any other existing state gun regulations might also be unconstitutional. McDonald, supra, stated that the Second Amendment is fully applicable to all of the states, but Wayne LaPierre expressed caution that the NRA has a lot of work ahead attempting to overturn other gun control regulations not covered by McDonald, while Paul Helmke voiced his personal opinion that the NRA was going to lose most of those lawsuits. Related cases. The day after Heller was filed, the National Rifle Association filed 5 similar lawsuits challenging local gun bans. Guy Montagdo v. San Francisco Housing Authority. In January 2009, the San Francisco Housing Authority reached a settlement in favor of the plaintiff, Guy Montagdo, which allows residents to possess legal firearms within a SFHA apartment building. 3 unnamed suits against the Chicago suburbs of Evanston, Morton Grove, and Oak Park. NRA v. Chicago, eventually merged with McDonald. Other notable post-Heller Second Amendment court cases. Nordic v. King, 563 F.3d 439, 9th Cir. 2009, held that the Second Amendment did apply to the states in the Ninth Circuit, though the ruling was vacated for en banc reconsideration, and the Alameda County, California prohibition of firearms on county property remained constitutional until overturned by McDonald v. Chicago. Maloney v. Rice, aka Maloney v. Cuomo and Maloney v. Spitzer, 554 F.3d 56, 2d. Cir. 2009, held that the Second Amendment does not apply to the states in the Second Circuit. The case involved a state ban on nunchaku sticks, a martial arts weapon. In a memorandum opinion dated June 29, 2010, the Supreme Court vacated the Second Circuit decision in Maloney and remanded for further consideration in light of McDonald's holding that the Second Amendment does apply to the states. State of Washington v. CIs. The Washington Supreme Court held that the Second Amendment is incorporated and applies to Washington state, via the Due Process Clause of the 14th Amendment. Superseded by, but consistent with, McDonald. Commonwealth v. Runyon, 456 Massachusetts 230, 2010, the Supreme Judicial Court of Massachusetts held that Heller did not apply to the Massachusetts state legislature and that the gun locks ordered under Massachusetts law are different from those regulated in Heller. Partially overturned by McDonald, the decisions made in Heller do apply to the state of Massachusetts, as with all states, but the gun lock requisite under Ma law may indeed differ enough from D.CS statute to be found constitutional. In Ezel v. Chicago, decided July 6, 2011, the Seventh Circuit reversed a district court decision that the post-McDonald measures adopted by the city of Chicago were constitutional. The Chicago law required firearms training in a shooting range in order to obtain a gun permit, but also banned shooting ranges within the city of Chicago. The city had argued that applicants could obtain their training at gun ranges in the suburbs. The opinion noted that Chicago could not infringe Second Amendment rights on the grounds that they could be exercised elsewhere, any more than it could infringe the right to freedom of speech on the grounds that citizens could speak elsewhere. In Moore v. Madigan, the United States Court of Appeals for the Seventh Circuit issued a ruling in December 2012 that required the Illinois legislature to modify existing state law to adopt a concealed carry law to allow the denizens of Illinois the right to bear arms outside of the home. In February 2013, the entire Court of Appeals decided to let stand the December 2012 decision of a 3-judge panel. Following a final 30-day extension, Illinois was required by the court to draft a concealed carry law by July 9, 2013. In the end, the legislature overrode a veto of the governor and approved Illinois concealed carry to begin January 2014, at the latest.
Please subscribe and thanks for watching.